everybody. My name is Cheryl Milne. I'm the Executive Director of the David Asper Centre for Constitutional Rights, the host of today's webinar on the Emergencies Act, police powers, and COVID protests. This webinar is being recorded and a link will be shared in the coming days. The panelists will be talking for about 60 minutes and there will be 20 minutes for question and answer following their discussion. Please use the Q&A at the bottom of your screen to type in your questions. I want to start by acknowledging that we are hosting this webinar from the University of Toronto, which is the traditional territory of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. Today, we are examining the government response around the protests or blockades that have been called the Truckers' Convoy in Ottawa and at borders throughout Canada. Ottawa experienced significant disruption with trucks blocking roadways, people essentially camped out and engaging in protests, as well as more troubling activities such as the incessant honking of horns and the harassment of local residents for approximately a period of 3 weeks. The blockade at the Ambassador Bridge in Windsor halted commercial traffic and led to labor slowdowns. The final dismantling of the blockade in Ottawa led to charges against over 170 people. We are joined today by our experts to comment on the extraordinary use of the Emergencies Act by the federal government and the actions of police trying to maintain public order. Kent Roach is Professor of Law at the University of Toronto Faculty of Law. He's a graduate of the University of Toronto and of Yale and a former law clerk to Justice Bertha Wilson of the Supreme Court of Canada. Professor Roach has been editor-in-chief of the Criminal Law Quarterly since 1998. In 2013, he's one of 4 academics awarded a Trudeau Fellowship in recognition of his research and social contributions. In 2015, he was appointed a member of the Order of Canada. He is the author of 15, I think probably 16 books now, including Constitutional Remedies in Canada, the winner of the Owen Best Law Book Prize. And the most recent book is Remedies in International Human Rights Violations. David Schneiderman is Professor of Law and Political Science. He was called to the Bar of British Columbia in 1984, where he practiced law and then served as Research Director of the Canadian Civil Liberties Association in Toronto. He was Executive Director of the Centre for Constitutional Studies and Interdisciplinary Research Institute at the University of Alberta. He has authored numerous articles and books on Canadian federalism, the Charter of Rights, Canadian constitutional history, and constitutionalism and globalization. Abby Deshman is a lawyer and the director of the Criminal Justice Program at the Canadian Civil Liberties Association. She also teaches at the Centre for Criminology and Socio-Legal Studies at the University of Toronto. Previously, she served as a corrections advisor on the Ontario government's independent review of corrections and as a senior policy advisor to the Minister of Community Safety and Correctional Services. She has led advocacy and analysis in a wide range of issues, including freedom of expression, peaceful assembly, freedom of religion, police powers and oversight, and the criminal justice system. Mary Eberts received her legal education at Western and at the Harvard Law School and is a member of the Bar of Ontario. She joined a Bay Street law firm after several years of teaching at the Faculty of Law at the University of Toronto and was a partner at that firm until opening a small firm specializing in charter and public law litigation. From this base in Toronto, she has appeared as counsel to parties and interveners in the Supreme Court of Canada, Courts of Appeal, and Superior Courts in Ontario and other provinces. She was active in securing the present language of Section 15 of the Charter and was one of the founders of the Women's Legal Education and Action Fund. Her work includes recognition of her work includes the Law Society Medal, the Governor General's Award in honor of the person's case, the Queen's Diamond Jubilee, and several honorary degrees. She's also a former constitutional litigator in residence at the Asper Centre. And finally, last but not least, Wesley Wark is currently a senior fellow at the Centre for International Governance Innovation in Waterloo, where he is co-directing a major project on Canadian national security strategy. He spent most of his academic career at the University of Toronto, where he taught from 1988 to 2013. Professor Wark served as a member of the Prime Minister's Advisory Council on National Security for 2 terms, and more recently he was an advisor to the Minister of Public Safety on National Security Policy and Legislation. So welcome, panelists. We're going to proceed through a series of questions, and we'll allow each of the panelists also to comment on the questions as they see fit. I'm going to start with a question for Mary Eberts. Can you describe what you saw as the difficulties that the various protests, occupations, and blockades posed for government?
3 of the blockades, the ones at Surrey, Coutts, and Windsor, created problems for Canada with respect to trade and international or bilateral relations with the United States. We know that there were also problems for the provinces involved because of the interference of those blockades with their local economy, and also with respect to Ontario. The domestic auto industry of Canada was seriously affected. As far as cities are concerned, I believe that at Windsor also was affected by the impact on its auto industry, and took quite a strong role and an early role in addressing the problems posed by the barricades on the Ambassador Bridge. It appears as if only Ottawa, the city of Ottawa, was affected initially in the first couple of weeks by the Ottawa blockade. Belatedly, I believe, Canada became concerned about the extent of foreign involvement in the funding and supporting elements of the blockade, but it was very, very late in the game, and probably after the declaration of the Emergencies Act, that Ontario became involved, and Canada.
Before I move on to the next question, does anybody else want to add to that in terms of the difficulties that that the protests and blockades posed for government? David, I see you've...
Well, there's much that can be said. And the argument in favor of invoking the Emergencies Act was that governments are simply incapable of responding to the various actions taken by truckers and others. And certainly the blockade of bridges was a problem, as Mary notes, but were all solved seemingly before the invocation of the Emergencies Act. And what I would call occupation in Centretown in downtown Ottawa was, I think, of a different sort, though animated obviously by the same objective, and that is to do away with all vaccine mandates at whatever level of government and by whatever authority. And that seemed to pose a very different problem, right? That those who support the invocation of the Emergencies Act, I did not, thought posed such special problems for government at every level that no laws were available otherwise to address. So address that occupation. And so that seems to me to be the focal point for much of the discussion I think that we're going to have.
I agree with David that the even the blockade of the Ambassador Bridge seemed to be relatively under control by the province and by local police officials, and similarly with Coutts and Surrey. But the Ottawa situation proved to be the one that was the most intractable.
Cheryl, can I just jump in and say very briefly that we'd probably have to cross-check the chronology very precisely, but my memory is the Coutts blockade had not been completely resolved by the time the Emergencies Act was declared. The Surrey blockade was ongoing. I'm not suggesting that these were the principal reasons for the invocation of the Emergencies Act, as I don't think they were. I think the occupation in downtown Ottawa was the principal reason. I think we're going to have an opportunity, obviously, to talk about the thresholds that are involved in an invocation of the Emergencies Act. And David and I stand on different sort of grounds in this regard, and I'm sure you'll hear more about that as we proceed. But one thing I think it is important to reflect on is that we actually had an invocation of 3 Emergencies Acts. There was, Ottawa was first in declaring its own emergency. The province of Ontario followed up after the declaration of the Ottawa emergency with the invocation of its own Emergencies Act. Neither of those invocations made a whit of difference on the ground. And it was only after some passage of time following the invocation of those two Emergencies Act that the federal government invoked its own legislation in that regard. So we have this kind of rolling landscape of Emergencies Acts, which prior to the federal government stepping in looked pretty ineffective from where I stood, certainly.
If I can just add from a policing perspective, my understanding is that the Emerson, Manitoba blockade at the border was resolved with the RCMP negotiating. And Coots is kind of interesting because the RCMP, I think, charged 13 people in total with weapons offenses and charged 4 with conspiracy to commit murder, is alleged to murder RCMP officers. And after those charges, and like Wesley, I'm a bit hazy on the exact dates, but after those charges, the leaders of the Coots protests, it's up to you whether you believe them or not, said, well, we didn't know we were infiltrated by these extremists, and therefore we're going to end our blockade at the Coots Alberta border.
I want to move on to the next question. We'll come around to some of these issues, I think, as we ask the other questions, because I want to turn to Abby Deshman. I'm sorry, David, I'll get to you in a second, but
It's about dates. I have the precise dates.
okay.
It'll take about 30 seconds.
Go ahead. Thank you.
The Emergencies Act was invoked on February 15th. By February 13th, the Ambassador Bridge is cleared. By February 14th, Coots is cleared. Emerson, interestingly, the next day, February 16th, and then Surrey, February 19th.
Great, thank you. So Abby, I want to turn to you because one of the other extraordinary things that happened was a series of court cases, so litigation by private individuals. The Ontario courts made a number of orders based on direct litigation against the protesters. Can you describe them sort of briefly and what their breadth was and what are the constitutional implications of those separate pieces of litigation outside of the Emergencies Act?
Yeah, for sure. I'll save my comments on the Emergencies Act for when we come back to it. So there were several, as you say, several civil suits, none of which CCLA was directly involved in. But we have been involved in civil suits and injunctions targeting protests in the past. So certainly I can comment on, the broader civil liberties and constitutional implications of civil law and protests, because there are some real concerns there. The ones that we saw in the trucker blockades context, so there was an injunction that was granted targeting the Ambassador Bridge. So that was brought by the city, but the Auto Manufacturers Associations also had a party status in that. And that injunction prohibited people from blocking the bridge, prohibited people from blocking routes that directly or indirectly led to the bridge, and also, prohibited harassment and intimidation of people enforcing bylaws, and reinforced, I guess, the application of several bylaws about parking and idling and things like that. We saw a similar injunction in Ottawa, right? So the city of Ottawa also went to court, got an injunction saying you should not be breaching parking bylaws, noise bylaws, traffic bylaws. You should not be intimidating and harassing people who are trying to enforce these bylaws. Shouldn't be supporting or encouraging people to violate these bylaws. And then probably the most interesting and the most talked about is the class action that was launched. So separate from the city's civil suit, there's a class action that's launched on behalf of downtown Ottawa residents, employees, and businesses. That is a nuisance class action. I have to get the exact terms, but the injunctions, so there was first an injunction targeting the horns, so the noise that was being created and trying to silence the truck horns. And then second, there is an injunction to try and freeze the assets that had been donated to the protest and were being held by certain people alleged to be protest organizers, so that those could be available in the event that the class action was successful and damages were awarded. So I think, the best way that I can think about the the constitutional implications of these is to think about, as I said, the broader context of how civil law is used. And these are very unusual protests in a lot of respects. And I think the use of civil law here is also unusual. Usually what we see is not civil law coming in to defend marginalized communities, which I think is a lot of what people thought was happening in Ottawa. It's usually civil law to target marginalized communities. So you can think of Indigenous activists that have been targeted and have been facing enormous cost orders and personal liability because of their involvement in various protests. Companies that have deep pockets and are able to use civil law and hire litigators to go to courts on an ex parte basis, to use injunctions to clear railways, to try and clear roadways in situations where the police are, drawing a firm line and saying there's a right to protest, we're not going to get involved, we're not going to actively enforce the criminal law in the way that the companies want, then they go to the civil courts to try and do that. So that's the usual context. And you can also think about defamation law, where people who speak up against large corporations or powerful entities regularly get really threatening demand letters saying, if you don't silence yourselves, you will be facing a lawsuit of X amount. And that's really effective in silencing people and scaring people and making them back down from what we would feel is appropriate and healthy democratic engagement. So that's the broader context of civil litigation and protests and criticizing people with powerful and deep pockets. And so when I see, class actions being used, when I see injunctions being used, that's usually where my mind goes. It's not the Ottawa protest, where we really did see a neighborhood and an entire downtown core rallying to try and impose what I think are frankly reasonable limits on horns. But I think about how a class action might impact Indigenous organizations or Indigenous protesters that are blocking access to land that they claim is theirs, and how communities that are impacted about that, may actually use class actions. It's can be a very lawyer-driven a legal tool to really stop those protests without even getting to a final decision. Lots of times the interlocutory injunctions or the demand letter is sufficient to stop the funding, stop the organizational support, target the organizers, and shut down that kind of activity.
May I just add something to that? All of the situations that Abby has described are ones in which the framework of Canadian law is the one that is applied. The injunction is sought under Canadian law. The class action is brought under Canadian law, and so on. The outlier here is a situation where an injunction application is brought by a developer or by someone with a license to explore minerals or whatever against an Indigenous entity, because there we have two sets of law, and that is that the Indigenous people who are demonstrating against pipeline or against development or on a railway are often, if not always, obeying Indigenous law, which binds them to defend the land. And one of the really distressing things about all of these injunctions that are brought against Indigenous people is that the role of Indigenous law and the obligations of Indigenous law are, if they're mentioned at all, they're slighted by the courts. And so applying for an injunction is basically a license to shut down a demonstration or to jail the demonstrators, because the Canadian courts will not give any weight to Indigenous law. And one of the elements that Abby mentioned, that is the Mareva injunction to seek the proceeds or the support that was being given to the occupiers in Ottawa, is another instrument of Canadian law that could well be turned against Indigenous demonstrators. And that is to seek costs against them, to seek damages against them for the interference to development or the interference to exploration that their demonstration has caused. That's happened once, to my knowledge, in Ontario with a minerals developer But because Ontario had not consulted, according to their duty to consult with the Indigenous occupiers in advance of issuing the license, Ontario was on the hook for $1.5 million in damages when the exploration was stopped. But it's just a matter of time before someone brings a Morava injunction against Indigenous protesters. So there is a great deal to be celebrated in what the citizens of Centretown did, but there are also enormous perils because Canadian law does not recognize Indigenous law.
Yeah, I mean, I would only add, I agree completely with the warnings that both Abby and Mary have given. From a point of view of Canadian law, one of the things that we've seen is because we don't have a modern law to govern protests, we really proceed often by government by injunction. So, you know, literally the criminal code provisions go back to reading the Riot Act, drilling. They've been in the criminal code since 1892. You know, we tried to modernize that with respect to intimidation and blockades of medical facilities arising out of the anti-COVID measures movement, or whatever you want to call it. But it was very piecemeal. That's one area of Canadian law that is lacking. And what Mary said, I agree completely about the lack of Indigenous law. And it even goes to not granting a person standing to challenge an injunction against an Indigenous protest or blockade under Section 35 of the Constitution Act. So it even goes farther, and so again, I join with my two colleagues who have said, although people may like the results of the injunctions in this case, be careful about how they will be used or have been used in other contexts.
It brings me to another question, and I know we'll circle back, and I just want to move us along through the agenda a little bit. But to some extent, sort of the comments about the use of these injunctions against Indigenous groups is a worry, and I think we heard a lot of comment in the media about, and from individuals about, saying that police would have behaved differently if this had been a different kind of protest involving racialized groups and Indigenous groups. And so I want to start with Mary, and then go over to Kent as well to focus a little bit on policing. And Mary, how did the behavior of the police have an impact on the protests in your view?
Well, I would like to start with the Ottawa blockade, and there are many things to be said about the policing situation in Ottawa. The hands-off response of the police there permitted the blockades to be thoroughly entrenched. And so we're left wondering whether the Ottawa police had any intelligence about the intentions of the demonstrators, or whether they simply believed what we are told. The organizers told Chief Slowly, and that was that they would only be there for 2 or 3 days, and they would leave an open lane on Wellington Street. So why was the police department so credulous of what the demonstrators said? That credulity, as well as the relative good cheer between the police and the demonstrators that was evident on the films that were shown, was really a signal, or a warning signal for many of us, that we had some white racism at work here, and that their reaction to the demonstrators in Ottawa was very, very different from the very harsh reaction of the Ottawa police to an earlier demonstration by Black demonstrators, and to almost every Indigenous demonstration that we can see. The only other possibility, mind you, is that there was no sort of intergovernmental, or no foreign presence. No foreign government was looking at what was happening in Ottawa. We remember what happened in the G7 in Toronto when all of those demonstrators, most of them white, were kettled in the rain by the Toronto police. And that was because of the police desire to look good in front of all of our international visitors. We didn't have that in Ottawa. So it really does emphasize the possibility that there was some racism involved. Another thing that it really makes us wonder about is what on earth did the Ottawa police see as their obligation towards the ordinary citizens of Ottawa? How do they regard their obligation to provide citizens of the city with the benefit of the law? They clearly were not doing it here. I have family in Ottawa who are reporting to me about their local stores being tormented. The keepers of their local stores are being tormented and threatened and maligned by demonstrators. And my own granddaughter was subject to some very unpleasant remarks by demonstrators wanting her to take off her mask and virtually everything else she had on, as well as, you know, all the other little girls or 12-year-old girls who were with her. So what did Ottawa police see as their duty to their citizens? We also were, I think, led to be concerned about what was the internal discussions, what were the internal discussions amongst the Ottawa police, because at one point, Chief Slowly said that publicly that this was a problem that might not be soluble by police. So what did he think of? What were the plans that they made that later he discarded or didn't see feasible, or did they make any plans at all? They didn't enforce the injunctions after the injunctions were obtained, and the the blockaders stopped obeying them after 3 or 4 days. They did, however, seem to do a lot of ticketing, which we saw after the demonstration had been stopped. They didn't issue all those tickets in just the last 2 or 3 days after the Emergencies Act was declared. They had over 1,000 tickets. So they must have been just going along in a peaceful way, giving people tickets. The last thing that I was very concerned about was the absence of the OPP from the scene. The OPP has a great deal of experience with demonstrations and had a very hard lesson taught to them after the Ipperwash demonstration, so that they are now well regarded for their approach. The OPP did not respond at all to any of the requests from Ottawa for assistance. The RCMP did not seem to be involved at all in the defense of the parliamentary precinct, although it was asked. And so we must ask ourselves why there was so little response to the Ottawa request for assistance. Is it because of the ancient system of organization of the police in this province, so that there aren't ready links to be made between them in such circumstances? Or do we have a situation where, because Chief Slowly was a recently hired Black reformer of the Ottawa Police Department, that he may not have enjoyed enough personal credibility with the other forces to have them rally to the defense of the Ottawa citizens? So there are some really very problematic concerns raised here that I'm sure my colleagues will be able to comment on more acutely than I.
I want to turn it now to Ken regarding what lessons we may have learned from policing in this, but then I'll also open it up to everyone else, because I'm sure you have views about the policing issue that then led to the federal government's action. So Ken, go ahead.
Yeah, well, I mean, one of the lessons is that police governance is a complete mess at all levels of governance. So the Ottawa Police Service Board didn't have an advanced plan about how to police Wellington Street, even though it did have advanced plans on how to police labor protests and Indigenous protests. And we saw at Police Service Board, as well as from the Ontario Solicitor General and the Federal Minister of public safety, both of them. This idea that because this involved police operations, they really had no role to play. But as the McDonald Commission outlined in 1981 and Justice Morton outlined in 2012, that's a really misunderstanding of the legitimate ambit of police independence, which we saw reflected in the injunctions, which said it's up to the police to decide when to arrest and detain. So really, we saw this lack of advanced planning that may or may not be related to intelligence, which I think I'll speak about later. We also saw a lot of political chaos and infighting in Ottawa. So Mayor Watson, kind of on his own, it appears, went off and started negotiating with the protesters about trying to move the rigs away from the residential center town to concentrate them on Wellington. Then, I think a day after Chief Slowly resigned, he had his supporters in a very acrimonious municipal council meeting that I watched and received criticism from my family for watching late into the night, removed the police, the chair of the police service board. And so basically we had a former chair come in, and both before and after that change, there was a palatable sense that this was a matter of police operations, and we'll just leave it to the police to figure out. And of course, that's just what Justice Morton criticized the Toronto Police Service Board for doing. And we tried to invite a member of a police service board to come and speak to this, but unfortunately, they were not able to do so. One thing that I will say, though, is the negotiations in Emerson, I think, should be viewed as a success. And the fact that police officers were seen talking to the protesters, I don't think in and of itself should necessarily be faulted. There are ongoing investigations into allegations of police members throughout the country, a few alleged to have contributed or otherwise supported the political aims of the protests, which is not proper. But I think that since Ipperwash, one of the lessons learned is to open up avenues of conversations with protesters. And of course, there are two ongoing SIU investigations, but other than those, it appears that the eventual clearing in Ottawa was done in a fairly methodical way.
I'll just jump in quickly.
Yeah, I was just going to say, before we go into the actual Emergencies Act, I'll let the other three of you to sort of jump in on policing, and then we'll move into questions focused on the Emergencies Act itself. So go ahead, Abby.
Yeah, thanks. So, I don't know what Chief Slowly meant when he said there may not be a policing solution to this, but I can say that is something that I tell public order unit commanders. So we do a training session. We have since the G20. Where I go in and speak to police officers who are taking the public order unit commander's course. And when I talk to them about what their job is at protests, I often do say, your job is not to resolve the underlying dispute between the people. There are often not going to be policing solutions to the situations that's giving rise to Indigenous people coming out and blockading a road or a rail line, right? That is not a policing problem. That is a problem for Canadian society. And so there's no policing solution to that problem, right? And I think in that sense, it's not what was happening in Ottawa reflects a very broad and very, and frankly, divisive and acrimonious discussion that has been building in Canada throughout the pandemic. That doesn't mean there isn't a policing role. And I think clearly, we often criticize police for overstepping what we think their role is and for not exercising enough restraint. That's our normal pattern, but there is also a role for police in protecting communities, and in particular marginalized communities that rely on public authorities for protection. And at least from my perspective, this was a situation that did require better policing, more advanced policing, more proactive measures to make sure that when people were engaged in public protest, that the city was still able to function, that residents were not harassed and intimidated, that we could have those two things happening side by side. And if steps had been taken earlier, I think that it might have not led to a lot of the extreme measures that were happening by week 3, 4 of the protest, the legal measures.
So Wesley or David, do you want to comment on the policing before we move to the Emergencies Act?
Cheryl, I'll just say very briefly that I think there's a fuller picture still to come in terms of policing failures. I think it's clear that there were policing failures in the early phases of the protest occupation in Ottawa in particular. I witnessed some of those personally on the very first day that the trucker convoy rolled into Ottawa. These will be the subject of Ottawa's own inquiry. Importantly, and we're going to talk about this, I hope, I assume there'll be a significant component of the inquiry that the federal government is obliged to call under the terms of the Emergencies Act. My own view, for what it's worth, and I think this is fairly clear, though the full dimensions of it we don't yet know, is that the Ottawa police and arguably other levels of government suffered a very considerable failure of intelligence with regard to the nature of the protest movement. They had 2 weeks warning that this was gathering, and it's difficult to know, where that failure lies and to what extent it's a failure of an ability of multiple levels of government to be able to communicate among themselves. I would say in that regard that the federal government is not used to and doesn't really have channels for sharing its intelligence with other levels of government, either provincial or municipal. And there are many complex reasons for that, but it is a reality. And this may be an important part of the story that we'll ultimately learn. In other words, that there was some knowledge about the potential threats and risks posed by the trucker protest that was not fully shared among other levels of government. But that's certainly a question I will look to see pursued in the various inquiries to come.
So David, feel free to comment on the policing, but I also want you to sort of transition into telling us a bit more about the history of the Emergencies Act. Why was it enacted, and what were the discussions at the time about its potential application?
Sure, happy to answer that, Cheryl. Thank you. So I had the good fortune of being a junior lawyer at the Canadian Civil Liberties Association in 1987, one of 2 in-house lawyers whose general counsel was Alan Borovoy, who was actually one of very few Anglophone political leadership or civil society leadership spoke out against the 1970 invocation of the War Measures Act. And Borovoy did that in 1970. I remember it specifically being a young boy, actually, in Montreal at the time. So as I say, I had the good fortune to work with him later. So he had a very specific interest in the replacement of the War Measures Act, which is what the Emergencies Act was proposed to do. And it was a very unusual set of circumstances. I've outlined these in an opinion piece in the Globe and Mail for those of the audience interested in learning more. But the Conservative government of Brian Mulroney was seeking to curry favor with Quebecers through the Meech Lake Accord in 1987, but also replacement of the War Measures Act, discredited, invoked by Justin's dad, which is why I was surprised, actually. I predicted he would not invoke it, but seeing as it turned out to be a black mark. So the Conservative government wanted to forestall criticism, at least very aggressive criticism of the act. The CCLA wouldn't decline from criticizing, but was just less aggressive about that, the outcome of the act after being consulted about its contents. The CCLA, along with the Canadian Bar Association, there were a number of lawyers, advisors to the CCLA as well, brilliant people who had some input into this. But what became clear as a result of or as a consequence of the negotiations between the federal government and these civil society organizations is that the proposed replacement needed to be cabined in. And the first thing to cabin it in would be having the act subject to the Canadian Charter of Rights and Freedoms. And so the Emergencies Act is forthright in saying that every measure taken is subject to the Charter. And then identifying with a little bit more precision the types of emergencies that might justify particular types of powers, so that powers are calibrated to the seriousness of the emergency. So we have public welfare emergencies, imagine fire or something of that sort, floods, public order emergency, which was what was invoked on February 15th, and then international emergencies, perhaps 9/11 actually might satisfy after the fact the circumstances justifying invocation of an international emergency, and then war emergency, World War. And powers are available to the federal government depending on the seriousness of the emergency declaration. So in speaking only to public order emergency, which was what was invoked in these circumstances, the objective of the CCLA, and I think reasonably achieved, was to make sure that there were criteria, relatively clear criteria, that would have to be satisfied for the government to invoke a public order emergency. In the opinion piece in the Globe and Mail, I suggested those criteria were not satisfied. In particular, there's a definition of national emergency, and that's defined as circumstances that seriously endanger lives, health, or safety of Canadians. And there are two instances where the Act indicates that other law need to be exhausted before invoking a public order or declaring a public order emergency, and that is that it exceeds the capacity or authority of a province to deal with the emergency, and it cannot be dealt with effectively under any other law of Canada. So there's that threshold requirement that other laws aren't available. And clearly, for instance, removing protesters at both Coots and the Ambassador Bridge without the declaration of a public order emergency, I think, underscores the capacity of government and authorities to effectively deal with blockades, if not protesters in Centretown. And there's a second threshold criteria, and that is that the circumstances giving rise to a declaration of public order emergency also amount to a threat to the security of Canada under the Emergencies Act, which is a pretty, it's broad, but pretty high threshold. And the relevant one seems to be under Section 2 sub D, activities that are directed toward or in support of threat or use of acts of serious violence against persons or property for the purpose of achieving political, religious, or ideological objectives in Canada. It's a very high threshold. And I don't think either of those definitions of national emergency or threat to the security of Canada really capture what was going on in Ottawa, although there were, of course, some extreme expressive activities being undertaken there. But overall, this wasn't about using serious violence against persons or property, or giving rise to urgent and critical situation that threatens lives, health, or safety. Okay, so those were the circumstances that gave rise to the Emergencies Act, very serious thresholds. And then what we'll be talking about in a short while, the various subsequent reviews that are required to be undertaken in Parliament or designating someone to undertake an inquiry. So after the revocation of the Act, there's a parliamentary committee that is required to be struck, representative of the parties in Parliament in both House of Commons and Senate. They're expected to report back rather swiftly. And then within 60 days of a revocation, an inquiry is required to be taken. And as I say, we'll talk more about that. So there's threshold criteria and then checks at the end of an invocation of an emergency, so that we learn right, about the circumstances that required or at least called for the invocation of the emergency, and really to offer political lessons and guidance moving forward for political actors and citizens.
Wesley, if you want to jump in here and talk about what you understand to be the thresholds of the Emergencies Act, and then others can jump in terms of the thresholds as well as the constitutionality of what took place. So go ahead, Wesley. And you're still on mute.
I'm unmuted. Sorry, thanks, Cheryl, for that. I fundamentally disagree with David about the question of whether or not the thresholds were met, although I appreciate the argument that he advances, and I think we will have an ongoing argument about these thresholds. The first thing I'd say about them is that they are, I don't think they're as simple and clear cut as David suggests. I think they're complex. I think they're interlocking, and I suppose, as is the case always with legal codes, they're subject to interpretation. I should have begun this with a confession, which is that, in my early life, I went on a wrong path and failed to become a lawyer. So I'm not a legal expert. I've just had a lot to do with the law over the years, as Kent and others will know, and have great appreciation for it. But I think in terms of the invocation of the Emergencies Act, there are a couple of things that probably need to be added. One is that it does require designation of an event as a national emergency. And I think that's easy to misunderstand, but the part of it that may not be subject to much misunderstanding is that it's meant to be an urgent and critical situation of a temporary nature. And it is often referred to colloquially as a last resort tool, which I think the Prime Minister referenced in his own remarks in the press conference on February 14th, where he announced that the government would be invoking the Emergencies Act. In terms of the kind of interpretation that we need to bring to it, I think it's important to understand that the Emergencies Act encompasses not both risks and threats to persons or property. It can be one or the other. And I think one of the cases the government has made, and this will be subject to criticism, is that a considerable part of the threat posed by the trucker protest, was actually directed against property, which they defined really in terms of critical infrastructure threats and the implications of those. And clearly we're going to need to debate that, but I think we're also going to need to debate that in the context of thinking about what's missing in the Emergencies Act from 34 years ago, and how the security situation in Canada has changed over that period of time. And in particular, the absence, we'll come to this, of any definition of critical infrastructure actually in the Emergencies Act at all, as well as I suspect many other parts of the vast landscape of national security law in Canada. With regard to, David is absolutely right that there is this interlocking piece in the thresholds between being able to identify something that is so serious as to be a national emergency. But the Part 2 public order emergency also requires that it arise from threats to the security of Canada. And as David suggests, that references directly Section 2 of the CEASES Act. And there are 4 parts to Section 2 of the CEASES Act. And the government could choose to invoke one or more of those parts. It only needed to invoke one, and the part that it did invoke was the part that David read out about activities within or relating to Canada directed to or in support of the threat or use of acts of serious violence against persons or property. And I just kind of repeat that definition because there are obviously different factors and variables in that definition, which I think need to remind us that there is going to be a lot of interpretive room for argument about whether the invocation was appropriate or not. And maybe we should also say that the other 3 elements of the CEASES Act definition of threats to the security of Canada that were not invoked involve these things. One is espionage or sabotage. And the conjoining of those things is curious, and we could have another discussion sometime about the ways in which the CEASES Act is vastly out of date, but that's for another day. Another part was foreign influenced activities, which arguably might apply to aspects of the protest movement. And the final is undermining or destruction or overthrow by violence of constitutionally established system of government. So again, the government had that menu to look at and chose to use a part of the CSIS Act, which we've grown used to thinking about in a very limited kind of way, which is in regard to concerns about terrorism. And I think that the way in which we've grown used to understanding that part of the CSIS Act, I think has confused and complicated our understanding of it in the context of the Emergencies Act. And I guess, Cheryl, the final thing I would say is that there's an important lawfulness aspect around the Emergencies Act, and that it'll be very important for us to debate. And the CCLA has taken an important stand on that, which I very much respect. I think we also have to ask ourselves about two other questions, which is, one of them is kind of embedded in the law itself, which is the necessity of using it. And another, which perhaps has less to do with the law, I'm afraid to say, but maybe most important to Canadians, and here, we'll have to think about that connection, is, was it the thing that was effective at the end of the day in ending a protest movement, which had grown, from my personal observation, very ugly and very disturbing in its anti-democratic dimensions in downtown Ottawa. So I'll just end there.
Maybe I'll jump in because we've obviously been at CCLA really vocal about our concerns that the thresholds of the Emergencies Act weren't met, and it very much follows the lines that David sketched out. And maybe it's useful to take a step back and say why. Like, why are these thresholds so high? This act does allow the executive branch of the government to bypass typical democratic channels, right? So we do not take umbrage with the fact that what was happening in Ottawa, what was happening in the borders were very concerning to many, many Canadians and of concern to multiple levels of government, right? So in that sense, yes, this is absolutely a national concern. But invoking the Emergencies Act allows the federal government to pass orders before and change, in effect, change laws before putting them before Parliament. They have to put them before Parliament afterwards. But we never actually started, the process of looking at the actual orders, because the declaration itself was revoked before Parliament started to consider in any meaningful way the actual orders. And if you look at the orders, this is, some of it concretizes some of the concerns that we have about using this act and how this act might be used to address future protests that may share many, many, if not all of the same general characteristics that just, were in place in Canada over the past month or so. So the orders that the government passed, their declaration of emergency covered the entire country. It wasn't targeted towards Ottawa or the protests at the borders, most of which were resolved without resort to the Emergencies Act prior to its invocation. The declaration covered the entire country, and the orders that the government passed covered the entire country. So every single Canadian was subject to the orders, and they were very broad, right? The orders that were passed said that people will not participate in a public assembly that may lead to a breach of the peace. Right? So that is one step further back from the criminal code that says you shall not participate in a breach of the peace. It gives police officers powers to arrest people if they're breaching the peace. But this prohibited activity one step prior to that. And it also prohibited people from providing support to people who participated in the assemblies. And it could have been any type of support. It didn't have to be support, bringing gas canisters to the protests. It was any type of support that you provided to people who were participating in these assemblies, whether or not that was linked to the assembly, and then allowed for bank accounts to be frozen for all of those people across the entire country. So we have extremely broad declaration of emergency and very, very broad orders that were not targeted to the situation. at hand and didn't provide, a due process or judicial oversight before these orders came into effect. And even though the federal government said we will use them in a targeted way, in reality, these were in the hands of local police officers and financial institutions who were under a legal obligation to go through their client lists and figure out if they thought any of these orders applied to people. And I think, if these orders had continued on, we would have seen more and more instances of these orders being used in situations that were removed from the original intent. We did start to see indications that, people were having their bank accounts frozen, and then the RCMP was trying to claw back some of the notifications they had sent. We did see suggestions that police in other areas that had not originally said they needed emergency orders were starting to say, you have to clear this protest because there are emergency orders in effect. And if you don't do so, your bank accounts might be frozen, right? So those are at base, there's democratic concerns, and then there's constitutional concerns about the breadth of the proclamation and the orders that were actually put into place that are also, the source of, some of our legal action.
So I have a question of fact that, I'm going to pose it on the basis that has been raised before and has been subject to a bit of controversy, and that is that the manifestations in Emerson and Surrey and Windsor were either cleared or on their way to being cleared without the benefit of the Emergencies Act. And my other assumption is that one of the very large problems in Ottawa was the inability of the Ottawa police to take effective action. And so my question is for Kent or others who are expert in police matters, is there, short of the Emergencies Act, any way of replacing or beefing up a local police force that is failing in its duty? Can we use the Police Act or some act in Ontario, for example, to just have the OPP come in and take over the duties of the Ottawa Police or some other thing like that? Or could it have been done under an Ontario declaration of emergency? I'm just thinking that, this whole thing leads so inevitably back to questions about what Ottawa Police were doing. So that's my question to you.
Yeah, my reading of the Emergencies Act, and I may not be correct here, but I can see nothing in the Emergency Act that deputizes the OPP and the RCMP. So my understanding is the OPP and indeed the RCMP can aid assistance without the use of the Emergencies Act. And in fact, Section 20 of the Emergencies Act is very explicit. And I don't know if David remembers from when it was drafted, and says the invocation of the Emergencies Act does not alter the control that either, in this case, the Ottawa Police Service Board or the OPP Solicitor General. So I don't think that the Emergencies Act was necessary to get the OPP or indeed even the RCMP to help. I did hear on TV concerns about deputizing or swearing in the individual members, but I've not been able to find any legal basis for that, although I have looked a bit for it.
I think the concern that they were speaking about was with respect to police members coming in from other provinces, that they would have to be sworn in to enforce the law of Ontario. But I didn't see anyone raising a problem about officers from any other place in Ontario or other forces in Ontario, like the OPP or even RCMP based in Ontario, coming in to help Ottawa. And seems to me that so much of this could have been solved if there had been a mobilization of other police authorities in Ontario to come in and do what Ottawa wasn't doing.
Yeah.
Go on,
Abby.
I mean, there definitely is precedent, right, without resort to the Emergencies Act for police from across the country to come in and assist. And the easiest one for me to remember, because I was there, is the Toronto G20, right? There were police from across the entire country that came in and were under the command and control of the Toronto Police Service. And those operated by the way of MOUs, right? There were MOUs that were created between police services that set out, who would be in charge. And there's been criticism of those MOUs and how, they were enacted. But certainly that has happened in the past. And I've seen, some indications of, some finger pointing in the media. And really, I think there's a lot more story to tell, and we'll have to wait for it all to come out about why, OPP and RCMP weren't made available earlier to the Ottawa police, and who's really to blame. But I think there's discussions that have nothing to do with the law that led to some of those outcomes.
Thank you both.
David, I saw that you were wanting to jump in on this.
I've got this wonderful chronology that the Canadian Constitution Foundation has provided us in their application for under the emergencies, invalidity of the declaration of the public order emergency. And I was just taking note that in the chronology at Sarnia Blue Water Bridge, the OPP was called in on February 8th. And by February 9th, it cleared the blockade. Now, I don't know who would have first line enforcement authority in Sarnia. Maybe somebody else might know this, but the OPP certainly had some role to play in removing that blockade.
Sarnia has a municipal police force.
Yeah, thank you. And then we also know that at Coots that the RC, there was a request that Jason Kenney made to the public safety minister. We don't know precisely, it hasn't been disclosed to us precisely what assistance Kenney sought or the public safety minister provided. So there was much cooperation, or at least potential for cooperation, that preceded any declaration of the public order emergency.
Yeah, and just following up, I mean, and I think Mary's quite right about this. There is an Interprovincial Policing Act in Ontario, SO 2009, Chapter 30, and it only applies, as Mary says, to out of province, and does not seem at first glance to include the RCMP. So for sure the OPP and perhaps the RCMP. And my understanding of Solicitor General Jones of Ontario was when the request was made by Chief Slowly for, I think he said 1,800, there were 100 of those that would be civilians. I think her reply was that she had forwarded that to the commissioner of the OPP. Whatever that means.
So before we turn to some of the questions from our audience, or the people on the call, and there are some really interesting questions that I will get to. I just want to turn now to the inquiry, and I want to start with Wesley in terms of what kind of inquiry should be called as required under the Act, and how do you envision that going forward in a way that's constructive?
Cheryl, thanks. And I think this is a very important question. And what we know from the Emergencies Act about the inquiry is that one has to be called. It has to be called within 60 days of the revocation of the Act, and it has a year to report. Other than that, there are no details provided in the Emergencies Act about the nature of this inquiry. And we may all have slightly different views about it, but probably we all hold a lot in common in terms of that inquiry. So I'll just very, very quickly list one of the, some of the elements that I think are important, and some of us on this panel are trying to put together a joint op-ed to support some of this. First of all, we obviously want a very serious deep dive inquiry. It needs to be independent. It certainly needs to be public facing, both in terms of its reporting, but its ability as well to call on members of the public and stakeholders that were affected by the protest. It needs broad terms of reference. It's going to need significant resources to do its work properly, and a 1 year time frame may sound to some members of the audience as a long period of time. But when you get to a complex inquiry of this kind, involving multiple levels of government and all kinds of trajectories of concern and criticism, a year is a pretty short period of time to do a full study. So the only way that it'll be able to succeed with those resources. And one of the key things in an inquiry is it has to have the ability to access the information it needs to come up with the answers that it has posed to itself. That is going to be very challenging, I think, in this context, and some on the panel have direct experience of this. But when I say access to information, what I'm talking about are a number of things. It's going to have to have access in some form or another to national security information in order to get a clear picture of what the threat assessment and the protest was and how it evolved over time. Ideally, though I can't quite see this happening, it should have access to cabinet confidences to understand how the government actually just made the decision, particularly through the Incident Response Group, which is the Cabinet Emergency Committee, how it made the decision to invoke the Emergencies Act and how it decided on the kinds of tools that it was going to bring forward in the Emergencies Act. And finally, it should ideally have access to privileged legal advice provided to the government about the invocation of the Act. All of this is, I think, going to be very, very challenging, and I hope that ways can be found to overcome. But this is one of the things certainly that I would pinpoint as a kind of key criteria for success of the inquiry. So, thanks.
Does anybody have anything else they want to add to the inquiry itself?
Yeah, I mean, just to agree with Wesley that it is going to be challenging, especially cabinet confidences, even the existing review board, review mechanisms, that's exempt. We have, Justin Ling has a report in The Guardian that there was some intelligence from the Integrated Terrorism Assessment Center, or ITAC, and Wesley would know this better than I, but my understanding is that although in CSIS, that's more of a clearinghouse and doesn't collect its own intelligence. And so, one of the issues is, were there ongoing CSIS investigations? Ought there to have been? And were the police informed of that? So that's just another concrete example of a thread that I think a meaningful inquiry will have to follow, but it won't work unless it has access to national security information, which I know from working on the ARAR and the Air India Commission is easier to say than do.
Well, I think it's really a basic necessity for any inquiry to have a subpoena power so that it can subpoena those who are amenable to subpoena. But it's easy to see from what's been happening with the inquiry into January 6th in the States that anyone who has a will to litigate requirement to appear before such an inquiry could easily exhaust the 1 year term. And so I think the issue of access to confidential information of any sort is really a difficult one for this inquiry, and I don't know how to deal with it. Anybody have any suggestions? Any super mechanisms we can insert into the inquiry to deal with it?
David, you were going to jump in on this.
Yeah, I don't have any experience with this, but Kent does. I mean, just subjecting this process to the Inquiries Act requirements would probably be initially helpful. But I wanted to talk about the litigation that's going on. CCLA has started, and I had a good discussion with my friend Sujit Chowdhury, who's representing the Canadian Constitution Foundation. And I just wanted to report, he was allowing me to report what the case management conference that they've had reveals. What it suggests, well, firstly, the Canadian Constitution Foundation, and I suspect the other parties as well, may at some future date ask for disclosure of those cabinet documents, in fact, everything the government relied upon, and are initially seeking disclosure only to counsel, right? So there'll be no public disclosure, but they'll fight about that later. So we could get information, cabinet confidences or whatever legal opinions, whatever they can get from either consent of the government, less likely than an order from the court. We might see stuff coming out of that. The second interesting thing is that the government of Canada is probably, though it's not certain yet, going to move to dismiss these applications for mootness. For two reasons. One is that the emergency is over, but that's not a good reason, right? You'd never be able to litigate these questions, given the length of time it takes to litigate. Emergencies will long be over. But secondly, because the public inquiry requirement in the Emergencies Act will serve all of the purposes that judicial review. That's the anticipated argument hinted at so far. So I don't think a judge will, mind you don't know what federal court judges will do these days, but it'd be strange, right, if a court were to agree that this kind of really untethered process will substitute for judicial review. And so my worry is that the government of Canada will seek a whitewash by appointing a former Supreme Court of Canada judge. One in particular comes to mind of recent memory, who served similar functions at the University of Toronto. So we don't want to see those kinds of things happen, and we need to forestall those kinds of things. I think the litigation will help, move us along, if not get us access to stuff that we might not otherwise have available to us through the public inquiry process.
I mean, we certainly initiated the litigation because, one of the things that we were attuned to is just a very politicized environment, right? Politicized about the invocation of the Emergencies Act, but also politicized about the pandemic. I do think a lot of the responses, both public and responses that we at CCLA have gotten, some of them have had to do with the Emergencies Act, but a lot of it has had to do with the pandemic and the focus and the topic of the protests, which is not why we get involved in this type of litigation. We do it because we're concerned about the democratic precedent and the constitutional rights and the impact on protests. But I do worry that a politically driven process and thinking about, how the elected members of parliament might look to establish this, and the government might look to establish that the inquiries under the act, that it's going to be difficult to divorce the politics. And one of the benefits of the courts, hopefully, is that you are significantly removed from the political fray. So we'll see. I mean, certainly we want a really robust inquiry, and I think there will be some work to do to encourage the government and to make sure as much as civil society can, as much as we all can, that the inquiry under the legislation is actually doing what we think it should be doing and being a meaningful check and deliberations on what happened.
So,
Cheryl, can I just say a couple of quick words about how an inquiry, however it's structured, might actually get access to national security confidential information, and just two things. One is that I think, under the kind of time that they're going to be operating under, the best way to do this, and I'd be interested in Kent's ideas about this, would actually be to frame a memorandum of understanding with the federal government and the key security and intelligence agencies about the information that they require access to. This is a standard process with review bodies, and I think it could work. Ideally, the memorandum of understanding would also be made public in the inquiry process. Secondly, with regard to cabinet confidences, I know we're probably inclined to think this is a target too far, but the Auditor General's Office has a special provision in its so-called performance audits to gain access to cabinet confidences. They're slightly restricted access, but it's a very interesting power and tool. They don't publicize it, they don't shout it to the heavens, but something very similar, I think, could be used by an inquiry. But at the end of the day, Abby's absolutely right. There will be a partisan dimension to this. And I think the degree of the partisan dimension or defensiveness in particular on the part of the government will depend at the end of the day on how strong a case they think they might have. If they think they have a strong case, they'll be less interested in a whitewash. If they think they have a really weak case, I can see whitewash being more thickly applied, but we'll have to see on that one.
So I
Yeah,
Sorry.
I would just briefly add that 1 year is, I mean, I don't know of any inquiry that's even really been able to get staffed up and going within 1 year. So that may be another aspect of the Emergencies Act that we have to look at. I imagine that people in Ottawa, rightly or wrongly, are probably also looking at, you know, given that Section 63 doesn't really nail down what is an inquiry, perhaps giving it to some of the existing review bodies, which at least have, you know, some of the facilities and clearances already in place to go to work. Now, whether that will command public confidence, given that our review bodies have changed fairly significantly and are not very well known to the public, I think is another question.
So I want to turn now to just some of the questions. We're not getting through all the questions that I had kind of come up with for this talk, because we do have some really interesting questions in the Q&A, and we don't have very much time left. So I just want to turn to some of them. And one, I mean, just sort of looking at the constitutional issues with the use of the Emergencies Act. It declares that it is to be subject to the Charter, but just saying so doesn't make it so. And so I just wondered what your comments are on some of the orders and powers under the Act, and whether they are in fact compliant with the Charter, or is it just by definition, because it's declared an emergency, that it would meet the Section 1 justification if they do override Charter rights. I'm thinking of the freezing of bank accounts and some of the other sort of powers that could be evoked under the Act. Abby, can we start with you on that one?
Yeah. So, I mean, we're certainly of the opinion that they were unconstitutional orders. And one of the main things that you look at when you look at constitutionality of an order that, you know, restricts peaceful assembly or limits, other constitutional rights is how broad is it? Is it overly broad to deal with the situation that you're targeting? So even if you think that the Emergencies Act was properly invoked, which we dispute, and even if you think that something was necessary under the Emergencies Act to deal with the situation in Ottawa, these orders applied across the country, right? They applied to every single person in Canada. So, you know, saying that the Emergencies Act is subject to the Charter, for me, it actually reinforces the constitutional argument. It says, actually, we thought about it and we want to make sure it's not a free pass for you to do whatever you want, to invoke this act whenever you want, and to make whatever orders you feel are necessary. This is actually a reaffirmation that the courts do have a role, that the Charter does have a role. And one of the things that has to happen is they need to examine the breadth of the orders that impact constitutional rights.
Leave it to anybody else who wants to jump in on that particular question.
Cheryl, can I just push back a little bit at Abby's description of the breadth of the Emergencies Act? And I reference a couple of things. One is the Canada Gazette publication of the Orders in Council. The other is the orders and regulations that are provided for under the Emergencies Act. And those orders and regulations, to start there, provide the government with the ability to designate what's called protected areas, which they proceeded to do. The legislation also refers to specified areas. But my reading of it was certainly that the Emergencies Act was meant to be targeted on those areas that were deemed to need protection, as is indicated in Section 19 of the Act. And in the Canada Gazette publication of the Orders in Council, there's no, I don't read that as a suggestion that this Emergencies Act is going to be applied everywhere in Canada or against everyone. It refers to continuing blockades at various locations. I suppose you can read that as anyone everywhere, but that's not how I would read it. And certainly the federal government's explanation of its use of the Emergencies Act was one in which it wanted to suggest, whether they were right or wrong about this, that it was a very targeted invocation of the Act. And I think that is provided for actually in the orders and regulations and in the orders and council description of the use of the Act itself. At least that's my view of this.
Well, we will have to agree to disagree in terms of, the scope of the orders that were actually passed. I think there was a very clear way for the government to have done geographic targeting, right? The Act actually anticipates that if the effects of the emergency are local, then the proclamation of the emergency needs to specify that. And then the orders can only have effect. Like there's a clear pathway that could have been used that wasn't used to narrow down the geographic scope. But there are arguments left, right, and center on this stuff.
So for my last question, I'm going to collapse 3 questions into one. And I'll give everybody a chance to sort of weigh in because I think it covers some of the other issues that everyone has said they wanted to touch on. And that there's sort of a series of questions about how does a democracy know when to criminalize protests? Where's this sliding scale from a protest that is from civil disobedience to the more criminal? Professor Roach in the question here mentioned the modernization of the laws around protests and demonstration. How would we see the development of these laws? And also how a democracy protects its sovereignty from international fundraising for a worthy cause versus foreign interference in paid protests or situations. So there's a lot in this question, but I think what I want to get at, and I know that Wesley wanted to talk about the modernization of the Emergencies Act itself, but I think that it also speaks to police, criminal law, as well as the Emergencies Act. And so Wesley, why don't we start with you with sort of, and just everyone briefly sort of talk about what they think needs to be the law, the law reform in this area to cover off these questions. And you need to unmute yourself.
Just trying to prevent my breathing from distracting everybody. Listen, I'll just be very, very brief on this. And my main argument is that with the public order emergency, we're dealing with 2 pieces of interlocking legislation that are over 30 years old. The Emergencies Act is 34 years old. The CESES Act is, I can't do the math, dates back to 1985. The kinds of threats to security that were imagined in both acts were of a time and place. And we live in a very different national security environment today and likely in the future. In particular, I think there's a lot of work to be done, frankly, to overhaul the CESES Act definitions of threats to the security of Canada. But in particular, with regard to the Emergencies Act, I think there are two key things that we saw brought forward and ways in which the government proved to be creative. And I use that word in brackets because I think it's a controversial use of the Act. But one was the one lack in the Emergencies Act is any definition of critical infrastructure, and so the government got creative in focusing on threats to property equaling critical infrastructure threats and justifying the Emergencies Act and some of the tools it brought forward in that regard. The other is essential services, which go undefined in the Emergencies Act. The government got creative in using that essential services component of the Emergencies Act to include financial services and the ability and gave themselves the ability to block personal and corporate accounts and to cancel insurance for truckers and companies involved and so on. and you know, as a amateur, not lawyer really at all, my feeling about it is that those kinds of components, absence of any reference to critical infrastructure, the sort of vagueness of a concept of essential services are two key things that need to be addressed among, I'm sure, many in the Emergencies Act if we're going to modernize it.
I'd like to just talk about one aspect of this question, although I think Kent may have started into an answer before I started. So go ahead.
Well, just briefly, I mean, in terms of modernization, if you look at the Public Order Act 1986 in the UK, which is now in the process of being amended, very controversial, but it has a different framework for regulating public protests, and also interestingly has provisions on racial and religious hatred, and there were some concerns about certain displays at the Ottawa protest. And then the last thing I'll say, and this also I think enters into the charter litigation, a lot of what Wesley's talking about in terms of essential services, critical infrastructure, may entail some revisiting of the 2001 Anti-Terrorism Act. I would be a little bit worried if this is a blueprint for the government's next kind of run at that. And if I was litigating against this, I would use the Anti-Terrorism Act as an example of a more proportionate approach, because I think that there are some real differences between the orders and the balance that was struck after 9/11.
Well, no, this isn't on the same topic as Kent, but it relates to one aspect of the question, and that is, you know, how do we deal with situation where our freedom of expression guarantee may actually give rise to to protests and actions that are very inimical to our democracy itself. And I remember being told by my constitutional law professor at Harvard about Felix Frankfurter, who was in a very mournful state of mind because he thought that freedom of expression, which he treasured dearly, had actually enabled the flourishing of Nazis in Germany in the 30s. And that has been a question or an issue very much on my mind as we see the extent to which the racist white right and all of its allies, who are in some cases very much in favor of getting rid of a government or even against getting rid of the borders of our country. What do we do about that? I am very loath to support a sort of general piece of legislation saying what a valid demonstration is, because that just will last about 15 minutes before it's outdated or got around somehow. And I think that in the end, we can strengthen a lot of our sort of related provisions like anti-discrimination and anti-hate provisions, and we can strengthen the institutions of government that support freedom of expression and demonstrations. But in the end, I hate to say it, we have to let some of this go. We have to let freedom of expression stand as a cardinal value without being hemmed in, except on a case-by-case as needed basis, preferably by the courts or by social consensus, not any general legislation about what is a proper demonstration.
And I'll just add from like a peaceful assembly focus, there has to be room for disruptive peaceful assemblies, right? There's a difference between disruption and violence. And I think the word peaceful, you know, there's a peaceful, quiet afternoon, and then there is a non-violent afternoon that can be quite disruptive and not peaceful, you know, but we have to have room for disruptive protests. That is just such the essence of protest is being able to make your voice heard by disrupting normal routine and activity.
Mm-hmm.
The closer we get to categorizing this disruption as unacceptable because of the daily lives of people, as a national security threat, because there are almost always people who come into large protests that are very interested in property damage and will commit criminal acts. That is a recurring feature of large protests. And so to allow those themes, which cut across a lot of different protest movements, to define and generate a very repressive law or police response really does really threatens the core of what we should see as protected democratic essential activity.
Well, lastly, we'll turn to you, David.
And appropriately, appropriately so. I'm not going to take more time, seeing as that we're out of it. Just to say that one of the chat questions was about Occupy protests, and the occupiers here in Toronto, I think Calgary and some other places, were staying in their parks. So they weren't occupying thoroughfares where they were in parks or plazas for a month before they were forcibly displaced. The truck convoy had about 3 weeks or so. But what's interesting is that, and Kent and I have written about this, Justice Brown authorized the removal of the Occupy protesters because they interfered with people enjoying the park, dog walkers and the like. We were of the view that wasn't sufficiently compelling. And the circumstances were much more compelling in downtown Ottawa. And so just that comparison is instructive. And I just want to know there's foreign funding is available in Canada outside of election campaigns. So I'd be a bit worried about it, as has been said. And also just to push back against Wesley about updating the CSIS Act. I agree it should be updated to prohibit CSIS from spying on the lawful activities of Canadian citizens, which is an old hobby horse of the CCLA. So curbing those powers would also be appropriate, I think. Thanks.
Cheryl, can I just say I don't disagree with David on that point?
Okay, great. That's a good note to end off on. So I want to thank everybody for an engaging conversation. One thing that I know we were going to ask David, but I just want to end with is that one of the things that we saw, at least through the media, was many of the protesters, not all, I'm sure, but many of the protesters showed significant ignorance about how our constitution operates and how our government functions. And so I think in terms of not necessarily law reform, but certainly our civics teachers have real tough job cut out for them to make sure that future generations do not actually mimic some of the comments and views that were expressed by the protesters in terms of how our Constitution works. But I want to thank everybody here for your time and your expertise. And we had a very engaged audience, and I know we couldn't get to all your questions, but thank you for joining us today.